operating vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the first degree, a lesser included offense of count 3, attempted aggravated vehicular homicide, a felony of the third degree, and count 4, failure to stop after an accident, a felony of the third degree. The court referred the defendant for a pre-sentence report, victim impact statement, and a drug and alcohol evaluation. Those reports have been completed and the state is prepared to proceed with sentencing.
Thank you. Mr. Weatherly, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Just briefly, Judge, if I may.
Sure.
Thanks, Judge. So, Your Honor, first thing I'm going to do is I'm going to offer my heartfelt condolences to all of you. These are the hardest things that folks in the criminal justice system have to deal with, which is the death of an innocent person. And I know people who don't spend a lot of time in the criminal justice system think, oh, this is just everybody's job, and they're here getting paid, and it happens all the time. Well, unfortunately, we do deal in death all the time, and it never gets easy for any of us. So my thoughts and prayers are with all of you, as are the family of the Hanasoskis. This is just a tragic situation. There's no two ways about it. In these cases, Judge, there's no accounting for the loss of life. There's no way to make up for it. There's no way to reverse it. And in addition to the loss that is suffered by the family whose loved one has died, we know that there will be loss to a certain extent on behalf of Mr. Hanasoski and his family as well. Generally speaking, and I know this sounds harsh, Judge, we're all okay with that, because if you take someone else's life, then you deserve to have severe and significant consequences placed upon you. But in normal circumstances, Judge, the person who causes that death did so with malice or did so with intent. And in these cases, it's so tragic because neither of those things are true. It's not being argued by anyone that Mr. Hanasoski had any malice towards the decedent in this case. There's an argument to be made that he ever intended to hurt anyone. And so that's what makes these cases, in some ways, even more tragic. Because we have someone who certainly didn't deserve to die. We have a family who's lost a loved one. And then we have another family who's going to see their loved one incarcerated, because that's an agreed upon portion of this sentence, Judge, or this sentencing. And he didn't set out that day to cause anyone any harm at all. Yet this is going to be his fate. And so I just wanted to ask the court to take that into consideration in moving forward. Judge, you've read the pre-sentence investigation, and I'm sure, as you've seen in many of these types of cases, we have an individual who scores exceptionally low, remarkably low on the risk and recidivism factors. He's been working as a blacksmith for 20 years. I didn't even know that they had those anymore. But he drives around and he takes care of folks' horses. And he's been doing that successfully for 20 years. He's an upstanding member of the community. He's a law-abiding member of the community. The pre-sentence investigation basically says it all, Judge, and I know that you read it, and I know that you know that that's a really low score, and that you don't often see individuals that hit those marks as Mr. Hanasoski does. As far as prior record is concerned, Judge, he does have the two prior operating a vehicle under the influence of convictions. The most recent of which is 2011, so 14 years ago. As this court knows, after my client was able to post bond in this case, he got himself right into an intensive outpatient treatment program. He completed that program. He's been sober since. He's not picked up a drink. He's not consumed any illicit drugs or non-prescription drugs of any kind since that time. He's been under the watchful eye of his family. And his loving girlfriend, who's been heavily involved in this case as well. So, Judge, it's a tragic situation all around. I know that this is one of those situations where I'm glad I'm not the judge, and so I don't envy you at all. Obviously, we know that Mr. Hanasowski has to go to prison, but I would argue that if we look at the pre-sentence investigation and if we look at the sentencing factors under 292912C, that a more lenient prison sentence, more along the lines of the minimum prison sentence, would be warranted. And Judge, of course, I'm focusing specifically on the more serious and less serious factors. If we're looking at the more serious factors, obviously we have one factor that weighs heavily against Mr. Hanasowski, and that the victim here did suffer serious harm. There's no further or more greater harm than death. But there are multiple factors which make an offense more or less serious, 9 in fact, and that is the only one that weighs against him. There are 4 factors which make the offense less serious. The first of which is that the victim induced or facilitated the offense. The second is that in committing the offense, the offender acted under strong provocation. That one absolutely does not apply. The third offense is that in committing the offense, the offender did not cause or expect to cause physical harm. Certainly he didn't expect to cause, but he did. And then factor 4, there is substantial grounds to mitigate the offender's conduct. So, Judge, I'd like to focus on the first and the fourth there. Judge, I know that you've forgotten more about civil law than I'll ever know. But if I recall from law school, there is something in civil law, I believe that it's the concept of contributory negligence. And unfortunately, it does apply here to a certain extent, and I'd be remiss if I didn't at least bring it up. In the decedent, we have an individual who had been struck once before by a motor vehicle in driving home from an establishment that serves alcohol because the motorist couldn't see him. These are 2-lane roads, Judge. They have no lights whatsoever, and it creates a dangerous situation. And although I can very much appreciate a person not wanting to cause harm to any other person after they've been drinking and choosing to ride a bicycle or an e-bike so as not to cause the harm that a motor vehicle can cause, it still creates a dangerous situation. So we're aware of at least one police report where the decedent was struck once before. We know that the decedent's family went to the extent of purchasing him his own bicycle that had more appropriate reflective apparatus, had a light on it even, because the bike he was driving before didn't. And we know from one of the letters that one of the patrons from the bar where he was went to the extent of paying for his own reflective vest that he wanted to give to the decedent so that he could wear it when he was going home, because there was such a dangerous situation created when he would go home from the bar. Unfortunately, this patron, this kind citizen, was never able to give him the vest. Still had it in his possession, was waiting to give it to him the next time he saw him, but didn't see him prior to this tragedy. So, Judge, there is some contributory negligence that exists here.
What is it? And you're referencing a prior incident. Prior incident has zero to do with this incident. What's the contributory negligence? He was riding his bike?
Judge, I think that on this particular road, with that lack of lighting, and not necessarily, no one can see what was going on, whether he was visible or whether he was not visible, because even the witnesses who were behind Mr. Hanasowski, they didn't see the decedent on his bike. They saw the truck in front of him, and then they saw the aftermath of the accident. So my suggestion is that this was an accident waiting to happen just on the dangerous circumstances created by riding a bike at night on this particular road that was not well lit, and doing it in a manner that history suggests wasn't the safest.
What was the manner he was riding the bike? Judge, I wasn't presented with evidence that he was in the road or.
And neither was I, Judge.
Right. Well,
so Judge, these are arguments that apply to the sentencing standards under 292912C.
It's a factor, but there's supposed to be evidence to establish that factor to consider it.
My argument is simply that it was a danger enough situation, Judge, that there were kind citizens in the community that we're trying to deter him from engaging in this behavior and that we're doing things to try and prevent this exact accident. And there is evidence to support at least those two things, Judge. And as far as recidivism factors is concerned, obviously my client has the 2 prior OVIs from 14 years ago. Other than that, none of the recidivism factors apply, and all of the factors that indicate that recidivism is less likely would apply to Mr. Hanasaski. So if we're looking at sentencing factors, if we're looking at criminal history, if we're looking at acceptance of responsibility and a showing of genuine remorse, if we're looking at a person who's lived a law-abiding life for a substantial period of time, 14 years since the last conviction of any kind, Judge, those legal factors do create a situation where a more lenient sentence is appropriate. My client didn't take this plea asking for the minimum sanction. The minimum sanction is for a community control sanction. This court has discretion to impose that. He's not asking for that. He's asking for a prison sentence that is commensurate with the behavior and the facts and the circumstances, as well as the plea that he took and the sentencing factors, Judge. And my argument, simply enough, is that if you look at the sentencing factors, if you look at the pre-sentence investigation, if you look at the facts and the circumstances of this case, although a prison sentence is appropriate, a more limited and lower prison sentence is what we would ask for, Judge, and we think that doing so would not minimize Mr. Hanasaski's conduct in this case. That's all I want to say, Judge.
Thank you. Mr. Hanasaski, you have the right to address this court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I would just like to offer my condolences to the family members of the passing of their family member. Over the course of this event, there really has not been a day that this tragedy has not crossed my mind. I think about it just about every day. I did that dual IOP course, and I'm willing to take the necessary steps forward not to drink alcohol again, or now I have the knowledge that any amount of alcohol is not allowed before getting under the driver's seat of a vehicle.
Judge, I forgot to mention one thing that I'm not sure if it's in the record or not. One of the reasons that this plea agreement was reached, and I know I had this conversation with the state, is that a discussion that was had was the level of impact of the alcohol that Mr. Hanasaski consumed that night, and whether or not it was greater than, less than, or equal to the other circumstances. And this falls in.
What other circumstances?
I'm about to explain them, Judge. I haven't gotten here yet. I apologize. Sorry. This would fall under the factor which indicates that there are mitigating factors that don't serve as a defense. This was a confluence of events. My client was working on his brakes that day, and that should be in the PSI, and I believe it made it into the police report. When you install new brakes, you have to then go check them by putting the brakes through a gauntlet of events, accelerating to a certain speed, maintaining that speed for a certain period of time, decelerating to another speed, maintaining that speed for a certain period of time, and then going back and forth.
It's in the record somewhere, or maybe it's in your client's version of what happened. I know I read that.
So that was the reason it's a topic for discussion, Judge, is because we're all drivers ourselves. And I spend a ton of time on the road driving from courthouse to courthouse, and I can't tell you how many times I've, been thinking about something else, or I'm talking on my hands-free system, and I'm not really paying attention to how fast I'm going, and so I look down at my speedometer to see whether I'm going the speed limit, or maybe even I'm above it. And just that split-second glance down, and I glance up, and all of a sudden, maybe I haven't deviated from my lane, but my car's moved within it at least. And sometimes it does deviate from the lane. And so I think one of the mitigating circumstances here, Judge, is that that's what he was doing. He should have been focused on the road, but he was also focused on following these procedures. He shouldn't have been doing it at night.
When you're doing it, you're not drunk.
No.
When he's doing it, he was drunk. That's apples and oranges.
Well,
I mean, if you're going to say solely that he was doing something else, focusing on his work and deviated, all right, we all have done that. But he was doing it under the influence of alcohol. Your example, you weren't under the influence of alcohol, I'm assuming?
I generally don't go to court appearances.
Well, I'm not trying to make a joke, but I mean, but that's the reason we're here. That's the reason we're here for a felony charge, is because he was under the influence of alcohol when all this happened.
Well, Judge, there's a version of attempt. I'm not going to argue with the court by any means.
He's pleaded to OVI.
I understand that, Judge. I'm not saying that the alcohol. My initial statement wasn't that alcohol wasn't involved. I never said that. What I said was there was a discussion as to the contribution of alcohol given the circumstances being that he was not as focused on the road as he should have been. And that also should be considered as a contributing factor. It's a fact in evidence that I wanted the court to consider, Judge.
Okay. Mr. Hansaskin, I'm not sure if you were done with what you had to say. I want to make sure you've said everything you want to. You don't have to say anything more, but I want to make sure you've had that opportunity.
Yes.
All right. Anything else then, Mr. Miller?
No, thank you, Judge.
For the state of Ohio.
Thank you, Your Honor. There is a joint recommendation for prison in this case, so this court does not need to consider whether community control sanctions are appropriate. But in regards to the prison sentence that this court imposes, it's the state's position that a minimum sentence here would demean the seriousness of these offenses. And that's for a number of reasons. And the first one is that the defendant has a criminal history. He has the prior conviction in 2008 for an open container and misdemeanor OVI, where he was ordered to the driver's intervention program and 6 months probation. And then again in 2011, he was convicted of another misdemeanor OVI, where he was put on 1 year probation and ordered to obtain drug and alcohol treatment. So despite those prior attempts at rehabilitation, here we are again after the defendant again made the conscious choice to drink and drive. So it's not fair, and you can't say that the likelihood of reoffending is low, because the defendant's criminal history demonstrates the opposite. Despite those prior attempts at rehab and treatment, by the defendant's own admission, he had continued to use alcohol weekly, consuming 5 to 6 beers at any given time until this offense happened. The defendant in his pre-sentence report talks about this offense and admits to hearing a large smack off the passenger side mirror. And he doesn't stop, despite thinking that he could have hit a mailbox. But I think what is more significant is that after that happens and the defendant continues to drive away, there are witnesses who had seen it happen and saw him continue to drive, and being good Samaritans, they follow him and they try and get him to stop his vehicle. And at one point, they're able to position their vehicle in a manner so that the defendant can't drive around them, and they get out and they approach the defendant to tell him, "You hit a person. Not a mailbox, not a sign, you hit a person." And even then, when confronted with that information, the defendant doesn't remain there for the police to come, which is what these witnesses had asked them to do. He drives around them. He drives around their vehicle, drives to his father's residence, where again, these good Samaritans continue to follow. And that's where the police department locates the defendant's vehicle as it's being backed in to a garage. Those actions, when confronted by what he had just done, is not something that someone does just when they're overwhelmed or confused. That was a calculated choice made on behalf of the defendant. A calculated choice made by someone determined to escape the consequences of their action. Defense today wants to talk about contributory negligence, but there is no contributory negligence in criminal law, and Mr. Weatherly and I discussed that point as part of plea negotiations in this case. And I think to discuss...
There's not a contributory negligence that can be a defense.
That can be a defense, yes.
Certainly something that's permissible to be considered as a factor making it less serious, which is where he was making his argument.
And it is something the state took into consideration as part of the reason for the plea offer in this case, and one of the reasons that we did reduce from the F2, aggravated vehicular homicide. But I think the one fact that remains is that if the defendant didn't drink and drive that day, that this wouldn't have happened. This tragedy did not come from an accident in the purest sense. It came from a series of choices. A choice to drink and drive, then a choice to flee the scene, and then a choice to flee again when confronted by the reality of what had just occurred. But this case is not just about the defendant. It's also about the life he took and the pain that he caused by his choices that day. Mark Mitchell was 64 years old at the time that he was fatally struck by the defendant's vehicle. His family describes him as having a good soul, as someone who was forgiving, who didn't hold grudges against those who treated him badly, even though he had been bullied throughout his life because he had a disability. And it's because of the defendant's actions that his family will never get to hear his voice again or celebrate a holiday with him. So the state is asking this court to impose a sentence that reflects the gravity of the crime, the loss suffered by this family, and the danger that the defendant poses to the public. And while defense is right that there's no sentence that will bring Mark Mitchell back, there is a sentence that can affirm to this family, to the public, that Mark's life mattered, and the choices that the defendant made that day have consequences. Thank you.
This court has reviewed pre-sentence report and investigation. I've considered the drug and alcohol evaluation that was completed. I received multiple victim impact statements, have read and considered all of those from family members of the victim. There was a sentencing memorandum that was filed, and I've read and considered that. I've considered everything that's been said here in court today. Mr. Weatherly, the defendant himself, the prosecutor, the recommendations from each side. I've considered the facts and circumstances of the offense involved, the nature of the offenses involved, and all of this is considered by the court in light of purposes and principles of felony sentencing, which are set forth in 292911 of the revised code. So the factors in 292912, the court does note, as alluded to, the victim here obviously suffered serious physical harm, the worst physical harm that you could suffer. He lost his life as a result of the defendant's conduct. Other relevant factors that can be considered by the court that aren't stated, but I find the fact that the defendant fled the scene to be a factor that makes this more serious as well. He struck an individual and just left. Now he wants to claim that he didn't know that he struck a mailbox. Well, two things. One, you're supposed to stop when you strike a mailbox, and you didn't do that. Two, there came a point where you were advised that you didn't strike a mailbox. You struck a person, and you continue to leave the scene. That makes the conduct here more serious. I don't find any factors making it less serious. I disagree with the defense counsel's assessment concerning the contributory negligence of them here. There was an argument alluding to another incident where he was hit, but that has nothing to do with this incident. As for factors indicating recidivism is more likely, the court notes the defendant does have 2 prior convictions for operating a vehicle under the influence of alcohol. Factors indicating recidivism is less likely. The court notes the defendant has led a law-abiding life for a significant number of years. Those prior convictions, as touched upon, were the latest was 2011. So it's 14 years ago. The 2 felonies in this case are both felonies of the 3rd degree. Neither carries a presumption one way or the other regarding prison or probation. The court does find that prison is consistent with the purposes and principles of sentencing. And the defendant is not amenable to available community control sanctions. You know, there was discussion made, and I agree. Defense counsel made a comment that there's nobody here that believes the defendant committed this offense with malice or some specific intent, and I agree with that as well. If there was, we'd be here for something much more serious than aggravated or attempted aggravated vehicular homicide. But there is still some intent involved in this case. You know, drinking and driving is a choice. And you made that choice to drink and drive. And you may not have intended to injure anyone or kill anyone, but everyone in our society knows the risks involved with drinking and driving. And the most serious risk that could happen is you kill somebody, and that's exactly what happened in this case. And you made the choice to disregard that risk, to take on that risk. And the most serious consequence from taking on that risk occurred in this case. And that is intent. Not specific intent, it's not purpose, it's not malice. But that's a choice you made, a decision you made. In this day and age, nobody should be drinking and driving. But if you do, you're fully aware, again, of the risk that you're taking on. Therefore, it'll be the sentence of this court. Then count 1, charge of OVI, defendant serve a term of 180 days. There's a mandatory fine that must be imposed in this count of at least $375, and that's what I will impose, a $375 mandatory fine. And suspend the defendant's driver's license for 3 years on count 1. On count 2, charge of lesser included offense of count 2, attempted aggravated vehicular homicide. It's a sentence to the court. Defendant be ordered to serve a term in prison of 30 months. On count 3, it's a sentence to the court. This is the failure to stop after an accident. Defendant be ordered to serve a term in prison of 12 months. Prison terms imposed in counts 2 and 3 will be served consecutive to each other for an overall prison term of 42 months in prison. Count 1 shall be served concurrent by law with those 2 counts. They must be served concurrent. On count 3, I'm going to suspend the defendant's driver's license for 3 years as well for an overall suspension of 6 years. Court finds in this case that consecutive service is necessary to protect the public from future crime and to punish the offender. It's not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that the 2 offenses for which he's running consecutive are part of 1 or more courses of conduct. The harm caused by the 2 offenses is so great or unusual that no single prison term for any of the offenses committed as a part of the course of conduct adequately reflects the seriousness of the offender's conduct. And quite frankly, there should be punishment for each of these offenses, particularly the added offense of failure to stop, especially after being told that he hit a person. And it deserves its own punishment and consequences. There's credit for 21 days. The defendant will be awarded that credit. So we ordered to pay all costs incurred in this action. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Felicia, is there anything else I'm omitting here I need to address?
Just, Your Honor, when you were imposing the sentence, you had referred to count 2. The prison sentences would be on amended, or the lesser included count 3 and count 4. I think you just mentioned.
Oh, I did misstate that.
But that is all.
So the attempted aggravated vehicular homicide is a lesser included offense of count 3. And that was a 30-month prison term. 12-month prison term for the failure to stop after an accident is count 4. And the prison terms imposed on those 2 counts are to be served consecutive but concurrent to count 1. Count 2 will be dismissed at this time.
That's all, Your Honor. Thank you.
Mr. Weatherly, anything else?
Judge, as to count 1, I think the court is required to impose points on the defendant's license.
That will be done by the clerk. I don't need to impose that specifically, but thank you.
The judge reviews the full record, rejects contributory negligence claims, and emphasizes the defendant's choices: drinking, driving, striking a person, and fleeing twice. Those actions trigger consecutive prison terms totaling 42 months, plus long-term license suspension and post-release control.